With substantive due process, the court has taken various approaches. In the earliest part of the 20th century, the court carefully scrutinized economic regulations. But later in the 20th century, during the 1930s, the court began to defer to economic regulations in O'Gorman, Nebby, and West Coast Hotel. And by the time you get to the 1940s and 1950s, the court announced that they would no longer use substantive due process to second-guess the legislature. All that would change after the 1960s, but at least until the 1950s, the court was taking a somewhat consistent downward approach. Okay. Any questions in substantive due process? Before we move on? Okay. We're going to start our afternoon session. We'll go for an hour and 15 minutes. And we will talk about another aspect of the 14th Amendment, which is the Equal Protection Clause. And specifically, in what instances can the state classify people on the basis of their race? The first two cases are very famous, and you may have heard of them. They're known around the world. They're known as the school desegregation cases. The first one is called Brown versus Board of Education, which I think most people have heard of. The second one is called Bowling against Sharp. Let's go back to Plessy versus Ferguson, 1896. In Plessy, the court recognized a separate but equal doctrine. The idea was, so long as you had equal facilities, they could be separated based on race. This institution gave rise to what's known in America as Jim Crow, which was state-sanctioned segregation, where in many states, not just in the South, but in the North as well, you had separate schools. You had schools for white children and schools for African-American children. They were completely separate. And the argument was that they were not, in fact, violating the Constitution. They were equal schools. In the 1940s, these laws started coming under challenge, but not in the context of primary schools. They did it in the context of colleges. For example, I live in Texas. Texas had one public law school at the time. It was only for white students. So the group said, well, there's no African-American law school. So what did Texas do? They opened up an African-American law school. The Supreme Court said, no, they're not equal, right? The white law school is much better. But those were only cases involving higher education. Those were not cases involving lower schools. In Brown, schools that had K through 5, kindergarten through 5th grade, were segregated. And those were challenged. And in Brown v. Board, the Supreme Court declared that public schools could not be segregated. The court did not overrule Plessy, and that's a common mistake. They did not. All they said was, in the context of public education, separate but equal has no place. Why? Because the children who were going to separate schools were not actually getting equal educations. In fact, they were being taught and reinforced to be supremacists and to reinforce certain tendencies of racism. And they found that, for example, black children who went to segregated schools were actually taught to think that they were worse off in society. Brown wasn't based on much constitutional law. It was based on policy arguments and social policy arguments. And as much as this case is, celebrated today, at the time Brown was very controversial because it didn't actually ground its decision in the 14th Amendment's Equal Protection Clause by overruling Plessy. They stopped short of doing that. The second case, Bowling v. Sharp, was a little bit trickier. Brown concerned schools from Kansas and other states. Bowling, however, concerned a school in the District of Columbia, D.C., we are right now. D.C. is a federal territory. The 14th Amendment's Equal Protection Clause only applies to states. Which amendment applies to the federal government? The Fifth Amendment. We studied that yesterday. The 14th Amendment has a due process clause. The Fifth Amendment does not. I'm sorry, I said it wrong. The 14th Amendment only has an equal protection clause. The Fifth Amendment does not have an equal protection clause. So there's a problem, right? The Supreme Court wrote an opinion that most people don't take very seriously, though I think it's correct, that the Fifth Amendment Due Process Clause actually prohibits racial discrimination. In other words, going to school is a form of liberty, perhaps, and the state cannot deprive a person of liberty on such an arbitrary basis as race. It's not exemplary, not like a model opinion, but what this effectively means is that both the state and federal government cannot discriminate on the basis of race unless they have a really good reason. I add that part at the end. You may ask, Josh, when would the state ever use race for a good reason?
Affirmative action. What?
Affirmative action. If you don't know what that phrase, affirmative action, we'll get to in a couple slides, is the use of race in admission decision for schools, for example, or government contracting, of whether you treat differently applications from certain disadvantaged groups. So there are instances where the courts do use race, and they say it's for a good reason. And we'll get there in a couple minutes, I promise, still very controversial. But as a general matter, race cannot be used. One other case to keep in mind was Korematsu, the Japanese detention case. That case allowed the use of racial classifications for Japanese people to put them into the exclusionary zones. Any questions on school segregation? Okay, next. The next case is a mess. Yeah, go ahead.
Just a question. I thought there was a difference between white and black school people. And people from other parts of the world, for example, Americans and others, they were selected to be in one of these schools. For example, if they are living in America at the time.
You're from abroad?
Yeah.
Yes. Yeah.
But the white one or the black one? What they were like?
So the question was, if you were living from abroad, from overseas, what school were you assigned to?
Yeah.
They had.
You had like another American school too, or no?
They had fairly flexible definitions of who was and who was not white. It wasn't rigid, to put it bluntly, and I'm sure people were able to sneak by. It was primarily a racial thing as African Americans, but there were Hispanics, right? There were Asians, there were other ethnic groups that were not required to go to segregated schools.
Okay.
Yeah.
Not required to go to.
I'm sorry?
Not required to go to.
Yeah. It's. I don't know exactly how they enforced it against different countries and where they fell on the scale, but I suspect it was primarily targeted to those in America. That's my guess. I'm not sure.
Okay.
Thank you for the question. Brown v. Board was decided in 1954. The Supreme Court said you cannot have separate public schools. Did that mean that every single segregated school shut down the next day? Not even close. Did it mean that every segregated school shut down the next year? Not even close. It would take decades, not days, not weeks, not months, not years, but decades before schools were fully integrated. Decades, I'm talking like 20, 30 years in some jurisdictions.
So early 70s.
70s, yeah. So there's still some school districts to this day, 2019, that are under federal supervision. Still to this day. But this raises the question, right? What happens to a school district that disagrees? This is the Cooper v. Aaron. In Little Rock, Arkansas, Brown was not a popular decision. In fact, the state took many efforts to block African American students from entering the white high school. There was a very famous incident here. Let me play this clip. This clip I think is worth showing to you. Yeah, it's about 2 minutes, but I think it's worthwhile to show you. So the set here, I'll just play this.
Governor Walter Fox ordered the Arkansas National Guard to prohibit black students from entering Central High School.
Units of the National Guard have been and are now being mobilized.
Basically, the governor of the state sent National Guards, which were state troops, to block black students from entering the high school.
With the mission to maintain and restore the peace and good order of this community.
The National Guard blocked 9 African American students, known as Little Rock 9, from entering Central High School. Neither Faubus nor the Guard were bound by the previous court order. After Federal Court joined the National Guard from blocking access for African American students, the Little Rock Police Department took their place.
So in other words,
The police had not been
initially it was the National Guard, the state troops. Court said you can't do that. So the governor called the local police department to block the students. It was like you ever know the game Whack-A-Mole, like at the carnival? We had a little hammer and you bang and the little thing goes up and down. They would keep shifting which level of government enforced the regime.
included in a court order that bound the National Guard. 2 days later, in one of the more dramatic moments of the Civil Rights Movement,
This is President Dwight Eisenhower, who was a president at the time.
President Eisenhower dispatched the 101st Airborne to Arkansas.
So effectively, the President of the United States sent in the U.S. military to integrate the high school in Arkansas.
My rule cannot be allowed to override the decisions of our courts.
These storied federal paratroopers had fought their way across Europe in World War II and held their ground at the Battle of the Bulge. Now, they were deployed to Little Rock, Arkansas.
This is a very dramatic picture, which you may have seen, of these federal armed soldiers escorting these 9 children, 17, 18 years old, into school. And they basically sat in the principal's office all day so they wouldn't get lynched. And what effectively happened is the guards had to bring them to school every single day. Almost a year. But it gets worse.
The troops escorted the Little Rock 9 into Central High School. Throughout the remainder of the year, the students attended class under the supervision of federal troops. Study guide. What would have happened?
Okay, so then this case gets even worse. Let's go back to our slide, right? It gets even worse. After this went on for a year, the school board said, we can't do this. We cannot have a school in which federal troops with guns are walking up down the hallway. I think that's not useful. So what they asked for said, look, we need more time. Give us about 3 years and we will integrate the high school in 3 years. We just can't do this right now. Give us more time. Right? And then the trial court, the district court actually agreed, said, okay, you get 3 years, right? I understand this is chaotic, this is not good. 3 years. The Court of Appeals reverses it. So then the case goes to the Supreme Court. And the Supreme Court has to decide, do they get 3 more years? The Supreme Court said no. We said in Brown, separate is not equal, integrate right now. What did the school do? What did the state do? Ready for this? They transferred ownership of the schools to private corporations. And we know private corporations are not bound by the 14th Amendment. They're not state actors. So effectively for years, there were no public schools in the American South. Years. In some districts, there were like almost 2 decades there were no public schools. They would just shut down all the schools.
But who finances public schools?
Oh, taxpayers. And what they would do is the taxpayers would fund the private schools. So then there was a lot of litigation over whether it's actually a public school or a private school. This went on for years. And in some districts, they would basically give parents vouchers to send their kids to whatever private school they wanted. Actually, last semester, this is weird, one of my students said, oh yeah, my mom went to a council school in Mississippi. And I said, do you know what that is? She's like, no. It was basically a private school set up by a white supremacist group to avoid taking to public schools. Like, she had no idea, and her mom didn't know. Her mom was like in kindergarten. She had no idea what it even was. But this went on for many years. The reason why Cooper is in this list of 100 cases is the Supreme Court said you can't have segregated schools, and then basically the entire country ignored it. Someone asked me that question earlier today. They didn't, disobey the Supreme Court, right? They simply just gave up their public schools so they didn't have to make them integrated. Which again, there's a subtle distinction. They're not disobeying. They're simply taking a shortcut around it. But this went on for years. And the Supreme Court, after Cooper v. Aaron, did nothing. They didn't touch any of these cases. They just like, all right, well, we made our ruling, now you go figure it out. This went on for years. I mean, there are entire generations of people who did not graduate from high school because the schools were shut down for a couple of years. Like there's like a lost generation. They just never graduated from high school.
So there were no public schools.
Depends. Some states set up private schools. Other states did like a voucher, and in some places they just had no schools. They just said, we're not going to do it.
And what about those discriminate? I mean, those schools for the black people. I mean, they were closed down because you cannot segregate anymore. So the black children.
I think all the schools were shut down in some jurisdictions. Rather than maintaining a segregated school, they just closed the schools altogether. This went for, I mean, I'm talking like some places like 10, 15 years. This went a long time. And this is a case I used to teach that, when the Supreme Court makes its ruling, that people have to accept it. And if people don't accept it, it's just paper, right? It's a ruling in name only if people aren't willing to accept it. I mean, the Supreme Court of the United States seems very powerful, but they're not when people don't like it. Often, judges from other countries visit our Supreme Court and they say, why is it that people follow your decisions? And usually they do, because people accept it. We had a case called Bush v. Gore, which concerned the 2000 election, which largely decided how the election would be counted. And after the President Bush won the case, Al Gore didn't say, let's go to the streets, let's burn down the Supreme Court. He accepted the ruling. Generally, in American history, people accept the court's rulings, but in this case, it wasn't the case. Was it?
They skip it. They don't say no, but it's
Yeah.
a way to.
Yeah, they evaded it.
Avoid it,
Yeah. Yeah, let me show you a picture somewhere here. Here.
Hours after the case was decided, Governor Fox released all of the public schools in Little Rock to a private corporation, which was knocked down by the court ruling. After the court halted the scheme, the government simply closed public schools for the remainder of the year.
Yeah, this one I'll show you.
These schools throughout
Basically, this isn't actually in Virginia, Prince Edward County. They just shut down the schools. They're closed. They just shut down the schools. And this happened in different contexts. There was one case where there was a public swimming pool. And the court said you have to integrate the swimming pool. Black people, white people can swim there. And what did the city, they filled the swimming pool with cement. They just closed the swimming pool altogether.
But what about the kids in those places, right?
They had no education. I'm telling you, there's a generation that there were no schools. They had zero education for that generation.
Unless you have money to.
Unless they went to a private school, exactly, yeah, but there's no public education.
But the public, I mean, the citizens of those states, they were all right with such.
They supported it. They supported that because they didn't want to have their children go to school with a black kid. This was a popularly enacted support. And until the popularity happened. Now, in Little Rock, a couple years later, people began to moderate a little, say, oh, this is insane. And eventually they reopened the high school, right? But for a couple years, just they were indignant, they were angry.
But wasn't there any kind of rebellion?
Any kind of what?
Of a war into this?
A war?
Not war, but rebellion, exactly.
President Eisenhower sent in federal troops to the South. This is like the Civil War, right?
Yes.
Yeah, the reason why those guys had guns, I showed you that picture, was because they were protecting the lives of these students. They didn't want these people to be killed and lynched. By the way, the word lynched, I don't know if you know that, but it's a mob that kills people in like a lawless fashion. I don't know if you have that concept, but it's like just like a mob killing. Is what lynch
But
means.
the lynch comes also from a surname, right?
Well, I don't know.
The word lynch, I think it was also some American
that-
history.
Maybe you're right. I don't know. I'm not sure about that. Never looked it up. Thank you. I always learn stuff from people whose English is not their first language. They don't assume things. They actually have to research it. So I'll check that later. I don't know. All right. Anything else in this case? It's a tough case. If you want, read the chapter. I sent it to. It's in your readings. But it's an important case. Okay, let's go to the next one. The next case, a little bit better, I think. I mentioned earlier the concept of eugenics, which was using science to improve the human genetic race. One way was to prevent imbeciles from reproducing. That was the first one. The second one was to prevent interracial marriage, because that was considered destroying the human race, having the races mix. In Loving versus Virginia, you had a married couple with a white husband and an African-American wife. They were arrested for getting married. They actually lived in Virginia, traveled to District of Columbia here, and they went back to their home after they were married. They were arrested. And they were basically, their sentence was to leave the state. The judge ordered them to leave the state for 20 years. And they did, and they lived in DC. Later, they tried to challenge their conviction. And the Supreme Court ruled that this racial classification was unconstitutional. That the separation of races was motivated only by white supremacy, and that was not a valid interest for the state. So once you get to the late 1960s, the court becomes more aggressive in policing race relations. But before, in the 50s, it was a little dicey. Okay? Any questions in that case? And the case has a lovely name, Loving, right? That was actually the last name of the couple. So it's easy to remember, love, right? Loving versus Virginia. That's an easy case to remember the name of. Now we get to affirmative action. I think you mentioned a couple, Ursula, right?
Andrea.
Ooh, no, Ursula, damn it. Oh, awesome. I remember names pretty quickly. If I had you for 5 days, I'd have all your names. But I'm working on trying. I give a seating chart. That you give me. All right. What does affirmative action mean? Like the word affirmative action, right? It's a phrase people use. They don't know what it means. Okay. So at a minimum, the state cannot discriminate on the basis of race, right? You can't say, okay, I'm admitting only white students, not black students. That's no. But what if you do something more? Not just being neutral, but taking specific steps, affirmative or positive action, to promote hiring or admitting minority applicants. That's what affirmative action means. And there's a very famous metaphor which I can use, right? Imagine we're all running a race and we all start at the same time we run. Okay, that's fair. But let's say, I start over here, you start over there, and you start in the back of the room. We have a race. Okay, that's not fair. So the idea with affirmative action is to give a head start to people who may otherwise have been held back in the past. Sort of compensate for past injustices, if you want to say it like that. There are different ways of phrasing it. Right? Someone mentioned reparations, I think, earlier this morning. It's in the same ballpark. So what happens? You have public schools in the university system, higher education, who take certain actions to admit more minority applicants. So the first case, number 59, was from the University of California. It was a medical school. And the medical school had 100 seats, right? There were 100 seats in the class. 100 people. 16 of those seats were reserved for minority applicants. Right? It was a quota, right? 84, anyone could apply for, but 16 seats reserved for Black, Hispanic, Native American, and I think a couple other groups. Okay? The Supreme Court said that's not okay. You cannot have what's called a quota. Right? Quotas, Q-U-O-T-A. You gotta have a quota because it's very rigid, right? It doesn't take into consideration who a person is, where they come from. It's only based on race. And that sort of racial classification is not okay. However, in 2003, a different program team came to the court. At the University of Michigan Law School, you're all lawyers, at the University of Michigan Law School, the court had a different program. Instead of only admitting people based on their race was considered one of many factors, right? So they consider your race, your background, what neighborhood you're from, and different considerations. And the court said that race can be used as one of many factors. It cannot be used as the only factor. So long as the word's holistic, you know that word, right? So long as race is used in a holistic, I don't know what that means, but and I speak English, in a holistic fashion, right? That just means how how could you hide the use of race? Basically, it's a game, right? They just pretend, but it's holistic. If you're using race in holistic fashion, it's okay. Grutter involved the law school at the University of Michigan. Gratz involved the undergraduate program at the University of Michigan. The undergraduate one was invalid because they basically said, if you're of a racial minority, you get X points in your application. You know what the SAT is, the exam? Mm-hmm. Having a perfect SAT score, 1600, was worth less than being of a racial minority. In other words, being a racial minority was more important than having a perfect SAT score on their ranking system, right? So 1600 SAT was worth less than being a certain race. That was no good. So in Gratz, the undergraduate program was invalid. But in Grutter, the law school was valid because race was used in holistic fashion. What does that mean? We will get more guidance about 15 years later in two cases decided fairly recently involving the University of Texas at Austin. Once again, you had a white student who was not admitted to the school of her choice, and she argued that she was discriminated against. By the way, all these cases are basically white kids saying that the school is discriminating against them. And there's some controversy over that, but that's where we are. Now there are extra cases by Asian students. This is a new front, because the Asian kids are really set aside because their statistically test scores tend to be higher, and schools actually have to degrade Asian students, otherwise they have too much admission. That's a new front of litigation. But at the University of Texas, the court basically reaffirmed that so long as race is used as one of many factors, it's okay. So that's where we are. Affirmative action is legal in the United States, but you have to just do it in a holistic fashion. There's not much more I can say about than that. There are very vigorous dissents in these cases. Justice Clarence Thomas, who is the only African American in the court, has been very vocal on this point. He sees that the use of race in affirmative action is a terrible idea. He says it's no different than segregation, right? That using race to help people is no different than using race to hurt people. That still degrades a person, that you're characterizing them based on their skin color. His own personal story was that he went to Yale Law School and he was admitted because of their affirmative action policy, and he resents it. He feels that he was cheated out of his degree. And then when people see he went to Yale, they think, oh, you got that because you're black. The opposite perspective is from Justice Sotomayor, who was also on the court. She also went to Yale right around the same time, and she's proud of affirmative action. And she says it gives advantages she otherwise would have lacked. So this is a very contentious issue. I think the court may go a bit the other direction. We have a more conservative court now. We have Justice Kavanaugh, Justice Gorsuch. So I think we may actually see some of these cases get chiseled away. Okay. Any other questions? It's the same person. Yeah, it's the same girl. Her case went to the Supreme Court twice in 3 years. The short answer is that in 2013, the court didn't resolve the entire case. It said, well, we're not sure. Go back to the lower court, think about some other stuff. And it came back up again a second time. That's the short answer. All right, anything else from Fisher?
I have a question regarding Supreme Court, like in cases like this, will the Supreme Court can still, for example, reject a case when it comes again?
Yes. The Supreme Court's docket is discretionary. They can choose or accept whatever cases they want. There's some exceptions where they have to take it, but almost every case is discretionary.
But even when they already have tried it once and this comes back to them, they can still reject.
Actually, when they take it once, they're more likely to take it a second time. It's like, they already know it, they're familiar with it. It's called we call it a repeater. They come up twice. That's a good question. And you noted that by calling it number one and number two, they just put a number after it. Sometimes they'll have the same case go three times. 3 is rare, 2 is somewhat common. Every couple of years you have a repeater. Happens. Especially if the first case didn't resolve the entirety of the dispute. There's still lingering issues. All right, anything else on this one? Okay, let's do the next one. Okay, now we go on to another type of discrimination. Not race-based discrimination, but discrimination on the basis of sex or gender, if you will. Throughout much of the 20th century, the court was only concerned about racial discrimination, right? You can't classify people based on their skin color. But there were plenty of cases that you can classify people based on their gender. Think of the minimum wage for women, right? Only women had the wage, not for men. And that was considered just fine because women were inferior and inadequate, and etc. In two cases decided in the 1970s, Frontiero versus Richardson and Craig versus Boren, the court reached a different type of conclusion, right? The court suggested that some cases, it's bad to discriminate on the basis of sex. In the first case, Frontiero, you had a woman. She was an officer in the Air Force. And her husband applied for some benefits, right? Now, generally at the time, all the officers were men and the spouses were women. Had a wife apply for the benefits, it would have been automatic. But the husband didn't get his benefits. Why? They said, oh, you're a guy, you can work by yourself, you don't need the government benefits. They said, you're not a housewife, why do you need benefits? And the Supreme Court said, no, you can't do that. You can't really presume that a husband is the breadwinner, right? The person making the money. And in this case, he was a student. He was actually working, and he depended on his wife for their living. So you can't use generalizations, stereotypes, right? That the husband is going to be the breadwinner. You have to be able to treat equal. Okay, that was Frontiero. Second case called Craig versus Boren. And this case was based on another stereotype, right? The state of Oklahoma allowed girls to buy beer at 18 and boys at 21. Mm-hmm. Now, they made all the girls very popular, I'm sure, so they can buy beer. But the idea was girls are more mature. They're more responsible. Mm-hmm. They won't drive drunk. Maybe, I don't know, right? People are actually nodding, yeah, that's true. Actually, I think this is a majority female class, or close to at least half. I'm not sure, I haven't counted, but no, most law schools usually tend to be more men than women in the States. There's a higher ratio. I'm good, I like it. Actually, I had a class this summer with 4 people, 3 girls and 1 guy. It was a great class, I really enjoyed it. Once the guy was it was a totally girl class, it's fun. No, it's good to have a good balance. I think you get a better education out of it. All right. So in Craig v. Boren, right? Girls buy beer at 18, boys buy beer at 21. The Supreme Court said, no, you can't do this, right? You're using a generalization that women are more delicate, they're not going to drive drunk, they're more well-behaved, and that's a generalization. Even though it might be a good generalization, you can't use that, right? You can't enact laws based on stereotypes of how you think women will behave. So that's based on something more, right? And generally, there's not a good reason to treat men and women differently. There might be exceptions, but generally, they shouldn't have these sorts of classifications.
Sorry.
Please.
Yes, it's just a generic question. I might have missed it. When you say Burger Court and before Roberts Court,
Those are the
mean
Chief Justices. Yeah,
right?
so for example, that's Chief Justice Berger, who was a Chief Justice in the 70s. And this is, I'll go back.
Roberts was
Yeah, so this is, Chief Justice Berger was from 1971 to 86, might be off by the year. So 1970s to 80s. And Chief Justice Rehnquist was from 1986 till 2005. And you call it the Berger Court. And now, Chief Justice Roberts was appointed in 2005, and he's still the Chief Justice. So you identify the court based on who the Chief Justice is. That make sense?
Yeah, thank you.
Yeah, we've only had, I think, 19 Chief Justices in 200 years. There are not many of them. And you stumped me before, but you should know most of them.
But Chief Justice is not a life tenure position, right? I mean,
It is, yeah. When they die or retire. So, for example, Chief Justice Rehnquist died in 2005.
And
He was
Chief
replaced by
Justice
Roberts.
He was Chief Justice.
Yes.
Okay. No, I thought that there was rotation.
No rotation. They serve till they die or retire, whichever happens first. And there's no mandatory retirement age. They can serve forever. So Chief Justice Rehnquist died in 2005. Chief Justice Berger retired in 1986. So they can go either way.
I have a question regarding Justice Ginsburg, because she's retired, right? But
No, she's not.
She's not.
She's alive and well.
But when they retire, are they then replaced by someone?
Yes.
Okay, so
That's why she won't retire, because she doesn't want to be replaced. Well, once she retired or is no longer living, then she's replaced. For example, Justice Scalia died in 2016 suddenly. And then President Obama tried to fill a seat. He wasn't able to, and then President Trump filled it the next year. The seat was empty for about a year.
Okay, so they had only 8, right?
For a year, they had about 8, yeah. Yeah.
But you said it's between 5 and 10 now.
But that's,
Who decides on that?
there were 9 seats, but there was 1 vacancy, there was 1 empty seat.
But you said that it's between 5 and 10.
Yes,
So-
yeah, well, that's by the number of seats that are available, right? Congress sets the size of the court, it's between 5 and 10. But you can have an empty seat, because no one gets put in time,
Okay.
right?
So it can just be like this forever, right?
I think it will come to be that if there's a president of one party and the Senate's controlling the other party, you'll have a seat empty for a couple of years. The Scalia seat was empty for about a year and just about a year. I think you might have a seat empty for 2 or 3 or 4 years. Rather than letting their opponent fill the Supreme Court seat, they'll just leave it empty, hoping they win the next election. Might go down to 8, 7, 6, 5, I don't know, might go low. Below 5, no trouble. I think you'll have 4 and below 5, yeah.
So governor replaced Scalia?
Justice Gorsuch filled the Scalia seat.
Oh,
The retirement clauses aren't limited or?
I'm sorry?
Or defined? I mean, why do they retire? Just because they are unable to perform?
They're about,
their duties
usually when they're
anymore?
really sick.
Okay, yeah.
Usually
I mean,
justice.
you cannot retire just because you want to.
You can, some justices want to go do something else. It's a very good job, it's very powerful. People don't like to walk away from powerful.
Yeah.
You know, for example, Justice Sandra Day O'Connor was the first woman on the Supreme Court. She retired in 2005, and she was in her late 70s, old but not old. And the reason why she retired was to actually take care of her husband because he had become senile. And then this is actually the sad part. He became so senile he forgot who she was. And he had to go home. And she later regretted retiring early. So usually they retire because they're about to die. Or they're very sick. You know, one justice, Justice Douglas, had several strokes and he refused to retire. And he was gone, right? His mind was gone. So his colleagues stopped letting him do anything. They said, we won't let you vote, we won't let you write any opinions. They basically just like put him aside. Eventually he stepped down. Justice Kennedy, for example, retired last year because he was done. He'd done it for almost 30 years. Like, okay, I did enough. But they generally retire when they're old, about to die.
So, they cannot be exposed to an interdiction or something?
None. And the president's in a coma. There's a way to remove him. If a justice is in a coma, you can't do anything about it.
Okay.
Yeah, it's like, if a justice is in a coma for years,
And what happened with the cases of his court?
someone else does it. You got 8 members. I mean, you can't
Ah,
vote,
okay,
but
that's
you
right.
can't replace them.
But it's actually quite a tough job because they meet every 2 times a week.
It's a cushy job, my God. Do you know how many cases the Supreme Court decides a year?
100.
That's 70. There are 9 of them. They each write about 10 opinions. It's not that much work. They have very smart law clerks, some of the smartest kids in the world. It's a cushy job. They work from October through June, then the summer's off. It's a really cushy job.
But they have to go for all those cases.
All the clerks do it. They don't. The judges don't do it. I'm not being mean, but most of the justices have very leisurely lives. I mean, they travel, they speak, different schools, they write books.
But are they allowed to do other things except for being justice?
Yes, they're allowed to teach, allowed to speak. They're limited how much outside income they can earn, but they have some discretion.
But you can get able to be a judge after how many years?
There's no time limit.
No, for a start, you can be like 35. You need to be old.
Well, the youngest justice ever was 35 when he was appointed to the Supreme Court. That's rare. Most of them are in their 40s or 50s, so they can serve 30 or 40 years.
Not that old. It's not like 60s or 70s.
Well, some were appointed in their 60s, but now the sweet spot is usually between 45 and 55, somewhere in that range. Get a good 30-year run.
What is the retirable age for a Supreme Court justice?
There's no retirement age. It's when they die. Yeah. There's none. None. I review them. I review their work. No, it doesn't matter. No. There's no assessment. They're not subject to anything. The Supreme Court's not even subject to an ethics code. It's completely above everything else. They are completely individual.
Do they have some
supervision on the other judges of the district court or whatever?
Yes, well,
They can be impeached.
okay, so judges can be impeached, that's true, but generally federal judges are independent, and they don't answer to anyone. They can't be removed unless they're engaging in a crime of some sort.
Yeah, but there's not a kind of pyramid that.
Their opinions can be reversed, right? Their judgments can be reviewed, but, you know, they do that, if they get reversed, it's not like they don't get punished for it. It's like, all right, whatever, we disagree.
And they are not liable for their decisions.
Liable for judgments or for damages?
Yes.
Oh my God, I wish we could sue a judge for a bad decision. No, you can't do that. That'd be awesome. Oh my God. I would file so many lawsuits. They would never hear the end of it. Suing the government's very hard. They have what's called qualified immunity, which means unless they violate a clearly established rule, you can't sue the government.
Or is in the Constitution that immunity?
Oh, I love you. No, that's not. You can't sue judges for writing bad opinions. Otherwise, all 100 of these would be based on lawsuits. Maybe like 95 of them.
If some judge issue a rule against one of my decisions that I'm involved.
Yeah.
And then later, 3 or 4 years later, someone reversed that. How I can get indemnified for that? There's no way I can sue the state.
No, I mean, one of the aspects of judges is they have basically not qualified immunity, absolute immunity. It's almost impossible to sue a judge. You know, maybe if you're working for a judge and he like harasses you, that might be the basis for one, or if he like, you know, abuses you. But if you are a party before a court, it's almost impossible to sue a judge.
Even if I can prove that his decision was based in not in the law, but in a personal or bribery or something like that.
Well, if there's bribery, that could be something you're removed from office from.
Yeah.
But that's gonna be the rare case. It's not just if he doesn't like you, that might be a basis to reverse the judgment in a court of appeals. But it's gonna be hard to sue the judge for engaging in bias against you. Yeah, they're pretty independent. It's maybe too independent. I don't know. Oh my God, I would love to be able to sue the Supreme Court for writing a bad decision. I think I would just, I'd be so happy.
Sorry, and the immunities you were referring to, the qualified one for the government and the absolute one for the judges?
Generally, yeah.
They are foreseen in the Constitution itself, or?
No. The notion of qualified immunity is nowhere in the Constitution. It's a judge-made doctrine.
Okay.
It's made by judges. You know, for example, if a police officer pulls you over on the side of the road and beats you up, right? Okay, they can't do that. You can sue them for damages. But let's say that, you know, they do something that's more borderline, right? Where it's not clear if they did was illegal. If there's some dispute about what they did, if it was legal, they get immunity, right? You can only sue them for damages if there's a clearly established right that they violated. That's how modern doctrine works. Now, that modern doctrine is not in the Constitution. It's basically made up by judges. Judges have absolute immunity. Prosecutors have absolute immunity, right? If a prosecutor brings charges against you based on some sort of bias, it's almost impossible to sue the prosecutor for damages.
But the immunity is based on his charges, on his position,
Yes.
not on the person.
Yes, because he holds that office.
Only in the execution of his position.
Yes. If he acts, you know, for example, if a government official, when he's driving home from work, you know, runs you over, he's not immune. But if he's under color of law, they say, acting in the color capacity of law, you can't sue.
And if there are like normal cases of the driving drunk, like let's say the justice, yeah, would he be then prosecuted or?
Well, yeah, in that case, if he's driving drunk, he's not under the color of law. He's not in his official capacity.
Okay, but then he can be stopped. He can be put to jail.
Yeah, I mean, if a judge is pulled over for speeding, he can be arrested. Sure.
And what happens then? I mean, is he then still? Okay,
Well, I mean,
justice?
assuming he goes to jail, he'll probably have to resign from his position, or he'll be removed. Right? There have been judges who've been accused of bribery. It happens, right? And they either refuse to resign, in which case they're removed, or they do the right thing, they resign. Judges get caught up in drug scandals. I mean, they have substance abuse problems. Not all judges are honest. They have bad judges. I'm sure in your country is the same.
But it happens that they are removed actually because of that?
Rare, but it happens. I mean, generally, if you're a judge, you're put there because you're in a position of trust and people respect you. But even good people sometimes go bad.
They're humans.
What?
They are humans.
Yeah, we're all human.
Are they be subjected for disbarment too?
Yeah, they can be removed from the bar as well. Yeah. And you know, some judges get caught up in debt. They get caught up in affairs with other women or men. They get addicted to drugs. They're human people. You know, when you read these 100 decisions, these were not perfect people writing them. They were, in many cases, these were awful people. They were awful human beings who were friends with the president, you know, or they knew a senator, right? You know, people are not appointed judges because they're upright and moral, because they're politically connected. I mean, I think in any country, if you want to be a judge, get to know the governor, right? That's no expression, right? Now, in some cases, people who know the governor are really smart, and they write smart opinions. Most of the time, most of the justices are pretty mediocre. Right now, of our 9, there might be 2 or 3 that are actually really smart, and the rest of them are whatever, right? They're just well connected. Most justices, they come and go, people forget them. They're not memorable. You know, there's some really big important ones, but most of them aren't because they're there because they're politically connected. So I don't treat what the judges write as gospel. I never do. It's not divine, inspired word. It's what we have. That's why I teach the Constitution first, which is what we have. That is the word. And then the judges say what they do about it. Anything else? All right, let's move on. We did the sex discrimination case from the 70s. Let's go from 1996. The state of Virginia operated a military academy, right, where they train people for the military. Only men were admitted. Only male students were admitted. Supreme Court said, no, you can't do that. You have to admit female students. Wait a minute, what about, you know, privacy issues? You're going to have male cadets and female cadets showering together, you know, in the same bathroom, in the same dormitory. Actually, someone recently told me that in Europe, at least, the military is completely sex integrated, that the men and women shower together. Do you know about this? I couldn't verify this. You say no? Okay. When a student tells me something, I just generally say, okay, and I don't, okay, thank you. But what the court said was, well, you know, maybe you can have separate dormitories or separate bathrooms, separate showers, but they have to admit it to the same program. You can't have another school with weaker programs and weaker academics than this military academy, which was very stringent. So even if this rigorous training has to diminish a little bit, that's okay, because you cannot keep women out of the program from this state school. Any questions on that one? Good, let's go on. The next 2 cases are a little bit odd, right? They don't quite fit in. They're not that gender. So the first case is called Cleburne versus Cleburne Living Center. And this case involved a group home for mentally handicapped individuals, right? People with low IQs. And the city said, we will not give you a building permit because we don't want you in our community, right? Because they may have all these reasons. Well, it might be dangerous, maybe they'll be abusive, maybe the children will be scared, and all these sorts of reasons. The court said, no, you can't do that, right?